Good morning, Sarah from Franklin Solicitors. So, could you tell me a little bit about you and your business?
Well, I'm a partner at Franklin Solicitors and we're based in Northampton and Milton Keynes. We're a multidisciplinary firm, so we offer legal services to businesses and individuals alike. And the exciting news is that later this month we're actually going to be moving from our Castilian Street premises into new premises on Billing Road in Northampton. Now, our offices in Castilian Street are still going to remain there, the teams will still be there as well, but our corporate services, our business services, will actually be opening in Billing Road, so it's a really exciting time for us. I joined the firm in 1992 and the firm opened in Northampton in Castilian Street in January 1983. So we've been there for quite a while, so it is a big step. And after joining the firm in 1992, I qualified as a solicitor in 1994, and since that time I've specialised solely in dispute work, so purely litigation as people may more traditionally know it, but effectively helping people in business and individuals who face conflict.
In over 20 years of dealing with disputes, how have things changed over that time?
They have really changed in that time. When I initially started, we would negotiate or litigate a case. Those were the two key things which you did, and most of the cases quite often went to court. And court in those days was very different. Certainly I can remember going into courts, and the smaller courts were called district judges' chambers. And I would go into a district judge's chambers, and on one particular district judge, he kept his pipe in the top drawer. And his pipe would be there throughout the whole hearing, and periodically he might open it slightly and you get this puff of smoke coming out of the drawer, and then he'd close it again. And I think if you were in there too long, it would just get really misty and cloudy. You just couldn't imagine that happening now, not at all. And along with changes in the way that the courts perform themselves and things that happen in the courtrooms, the legislation's changed too. There's much more emphasis now, following the civil procedure rules coming in, for parties actually resolving the disputes themselves, looking at alternative dispute resolution. So with alternative dispute resolution came in mediation, and that empowers the parties that are willing to look at what options are available to them themselves to make their own decisions rather than relying upon a judge to make that decision for them.
If someone was deciding whether to litigate or mediate, what are the main differences?
Who makes the decision? That is the biggest difference between the two of them. In litigation, it's the judge that makes the final decision. He will hear evidence from both sides, he'll read witness statements, he'll hear from both parties, he'll look at case law, he'll look at legislation, and he'll weigh up the pros and cons for both cases, but ultimately the decision rests with him. In mediation, it's the parties who make their decision. They have to be willing to go to mediation in the first place because it's a voluntary process, but they're there to make their own decision. And actually that is fantastic because it enables them to bring their business acumen to the environment to form a decision and an outcome that works for them. Whereas the judge in court is actually stuck with what precedents there have been and what remedies the court say are appropriate to the set of circumstances. It's really inflexible. And when you're in mediation and you can actually find your own solution, that better solution, it's a much easier way to resolve a dispute. In addition to that, mediation, as I've mentioned, is voluntary, whereas if you're in a court process, then you're stuck really. You're sort of forced along the way, and it can go on for years, whereas a mediation, well, it can be over and done within a day. The cost as a result is much less. You can resolve it at a fraction of the cost, whereas if you obviously go through quite a lengthy litigation case, then the costs are significantly higher.
I know all of your work is confidential. Can you give us any examples though without naming names?
Yeah, work as a solicitor and a mediator is always confidential. Certainly as a mediator, I've helped a family business have an honest conversation well, and I think that's really important. Sometimes it's about bringing people together who know and love each other, in particular from a business point of view when a family's working together, but actually who struggle to communicate, and sometimes just having that third party intervention to help facilitate that communication and enable people to put forward their views in a really appropriate manner to make sure that they get heard is really, really constructive and helpful. And in another situation, I brought my mediation skills to a negotiation. I was sat in a room with a client who bluntly was struggling. It was a difficult situation, and actually when you looked at the contract, he was really in difficulties legally. And we were faced with another solicitor and his opponent. We were sat down in the room, and the solicitor was presenting a really strong case, really, really well. And I knew that my client actually hadn't got the money to be able to settle the dispute, and if it went to court, he certainly hadn't got the costs in order to fund the litigation. So actually, if the matter had gone on much further, he was probably going to wind the company up, put it into administration, and ultimately he would have lost, but also the other party would have lost too. But as the other solicitor was talking, I could sense that his client was becoming more and more uneasy. You know, you could hear how strong his case was, and yet there was just something which wasn't settling right with him. So when we got to the end, I stopped and I said, look, I think it might be helpful if the lawyers stepped out the room. Let's just let our clients have a conversation and see what they come up with. And actually when that happened, half an hour later, they came out of the room and had a really honest conversation. It had been all confidential, it was without prejudice, and they both admitted that they were in financial difficulties. In actual fact, from my client's point of view, he learned that his opponent had a 2-week run on cash flow, and if he didn't get cash flow through, he wouldn't be able to pay wages bills. So they were able to come up with a solution together. They put in their business skills and decided that actually they both wanted their businesses to survive. They didn't want to go to court. They placed interim payments in part of a settlement agreement and then pursued that instead. So the law went to one side, the solicitors went out the room, but actually the parties got their heads together and came up with something that really worked for them. I think that was a great way of actually resolving it rather than resorting to a courtroom, which wouldn't have worked for either party.
It sounds as though people deal with disputes differently. Have you spotted any trends?
It's interesting, yeah, we all deal with disputes in different ways. I think one of the most common things we hear about is when we deal with a dispute or deal with a traumatic incident and people say, you know, do you flight, fright or freeze? And actually people do tend to fall into various categories. You might be someone who confronts the situation or avoids it, or maybe collaborates, you know, tries to find a way forward. And in certain situations, people refer to that as either being a peace breaker, someone who's actually going to aggravate the situation but always push until they get what they want, or a peacemaker, someone who steps in, tries to find a way forward for everybody. There are also those people who are peace fakers, who kind of keep quiet, who fly under the radar a little bit, don't say anything, and yet bubbling underneath there's a lot of anxiety and tension that they just don't want to let people know that they don't agree with what's going on. And actually that is a really sad place to be, because if people can actually communicate and say what they feel, then a lot of that worry and concern that they might be carrying inside then dissipates and can be lifted. So in actual fact, certainly how we deal with a dispute and recognising how we deal with it can be really important.
What advice would you give to somebody facing a dispute?
The solicitor and the litigator in me would always say, make sure you keep all your evidence together, so documentary evidence in support. But I think it's also important just to, when you've got that head of steam and when something's really agitated, just to pause, take a breath and think about what the other person's also thinking too. The reality is that if your case goes to court, the judge is going to hear what the other side have to say. So far better, don't wait until then. Don't wait until your solicitor has given you all the case law to support what you want to say, but actually step into the other person's shoes, look at it from their point of view, because that can actually give you insight into what they're planning to say, what they may argue in court or in front of anybody else, but also how you tackle what they're going to say as well. It puts you in a much stronger position. So collect your evidence, walk in someone else's shoes, look at it from how somebody else might actually approach the dispute, but keep communication open as well. I think quite often the longer a dispute continues, the harder it can be for the parties to actually take that step back. They become entrenched in their position, and actually early on, if you keep that flow of communication going, then you can get a resolution much more quickly and easily.
Thank you for your time here this morning, Sarah. It's been lovely to speak to you.
You're welcome.